in the early 2000s. It was Democrats who very willfully invented a brand new strategy to make judicial ideology, and not just qualifications, an acceptable criteria for tanking presidential nominees. I remember reading in the early part of Bush 43's first term, a seminar that was convened by my friend, the Democratic leader, and he invited a couple of scholars, Lawrence Tribe and Cass Sunstein, to come talk to him about the appropriateness of beginning to use every single tool in the toolbox to stop judicial nominations. It was always possible to filibuster judges, it just wasn't done. I mean, there are plenty of things you could do that you don't do. It just simply wasn't done. And the best example of that was the Clarence Thomas nomination. There couldn't have been a more controversial nomination than that one. The chairman of the Judiciary Committee, Joe Biden, and Ted Kennedy sitting next to him. It was about as aggressive as it gets. It made, in some ways, the Bork treatment look like child's play. The committee reported out Justice Thomas with an even vote, even. And as we all know around here, it only takes one of 100 senators to make you get 60, just one. Only one to get the Senate in a place where you have to get 60 votes. The tradition of dealing with the judicial nominees with a simple majority was so strong that not one Democrat, not one, required 60 votes on Clarence Thomas. In case you don't remember the vote on his confirmation, it was 52 to 48. One senator out of 100 could have denied Clarence Thomas his career on the Supreme Court. That's how strong the tradition was of dealing with the judiciary in a simple majority way. Well, in Bush 43, my colleague, the Democratic leader, at this meeting apparently with Cass Sunstein and Lawrence Tribe, I'm paraphrasing, I'm sure, was predicting all of these crazy right-wing judges were going to be sent up by Bush 43. We ought to use every tool in the toolbox, whether it's used before or not, to stop judicial nominees. So Democrats used the brand new tool, the partisan filibuster, to block one Bush nominee after another whose qualifications nobody even disputed. In her own confirmation hearing years later, for example, now Justice Elena Kagan went out of her way to say that Miguel Estrada, a name some of you may not be familiar with who got here recently, would have been qualified to sit on the D.C. Circuit. She said he even would have been qualified to sit on the Supreme Court. He became the poster child for this new process invented by the Democratic leader and his colleagues to routinely filibuster judges. It was written, the suspicion was, that it might provide for Bush 43 the opportunity to name the first Hispanic Supreme Court justice, and of course, they didn't want that to happen. So Senate Democrats filibustered him 7 separate times in 2003. He was one of the many victims of this norm-shattering, precedent-breaking behavior. A few years later, colleagues such as Senator Biden, Durbin, Leahy, Obama, and Schumer tried to filibuster Justice Alito's nomination to the Supreme Court. Fortunately, that was not successful. But then something really funny happened. Something really funny happened. All of a sudden, it was a new president, President Obama. Suddenly, a Democratic president was making judicial nominations. Well, imagine what happened then. Suddenly, Senate Democrats became very allergic to experiencing the effects of what they had started. in effect, the effects of their own playbook. They had no patience to taste their own medicine. None whatsoever. Colleagues did not appreciate being held to the standards they had just created a few years before. The shoe was on the other foot. Well, we all know what happened next. Another massive Senate-shaking escalation by Senate Democrats in 2013, the nuclear option. They broke the Senate rules to change the Senate rules so that a Democratic president would not have to play by the same rules they had invented shortly before. And with a 51-vote threshold in place, Democrats began confirming nominees without meaningful minority support. I said at the time, quoting myself, they'd regret it a lot sooner than they would think. Well, that regret began in 2016. In 2016, when Justice Scalia passed away, Senate Republicans had won our majority a year later. As I said then, when I recommended to all of you that we not fill that vacancy created in the middle of a presidential election year, that you'd have to go back to 1888 to find the last time a Senate of a different party from the president confirmed a Supreme Court nominee to a vacancy created during the presidential election year. In other words, not surprisingly, one party in control of the Senate was less inclined, and had been less inclined for a very long time, to confirm a Supreme Court nominee in the middle of a presidential election year. Entirely within the rights of the Senate to do that, because what had clearly developed over these years was the Senate viewed itself as a partner in the process. The president gets to nominate, but we get to decide whether to act on the nomination. Needless to say, after the unprecedented Senate-shaking steps that Senate Democrats had taken, the Republican Senate majority was not much inclined to depart from precedent and do President Obama that favor. Our decision in 2016 was fully in line with precedent, fully within the Constitution, and completely within the Senate rules. Now, I understand why they didn't like it. I wouldn't have either. Of course they didn't like it. But elections have consequences. And America had chosen a Republican Senate in 2014. But there's no parallel between actually breaking the rules, as the Democrats did in 2013, and merely applying the rules in ways that Democrats do not like. Big difference between breaking the rules and applying the rules in ways the Democrats did not like. If the Senate's going to function, we must maintain a distinction between when people break the rules and when they apply the rules in ways we may not like. When President Trump won in 2016, Senate Democrats took yet another reckless and unprecedented step. They mounted the first ever successful partisan filibuster of a Supreme Court nominee. That had not been done before. Tried it on Alito, it didn't succeed. Tried it on Gorsuch, and it did. So the message was, in effect, nobody who President Trump nominates is going to get 60 votes for the Supreme Court, no matter how qualified. Of course, speaking of qualifications, Justice Gorsuch's qualifications were simply beyond question. Someone who, frankly, has gone on to issue some rulings, by the way, that these guys over here like, which shows you predicting what a Supreme Court justice is going to rule on has been a hazardous guess most of the time. There are apocalyptic threats about predictions about what's going to happen with nominees of Republican presidents that have been consistent going back to John Paul Stevens. Every single one of them is going to be a disaster for women and minorities and all the rest, none of which, of course, ever materializes. So Republicans applied and extended what Senate Democrats had begun in 2013. They had left out the Supreme Court from being dealt with a simple majority. And so we decided, if we're going to return to where, by the way, the judicial calendar was by practice anyway just a few years ago, it was always dealt with a simple majority. The Thomas nomination proved it. That was the custom here until our friends on the other side decided to start a new custom within the rules, but a new custom. So all, my friends, that's happened as a result of the threshold being lowered for the Supreme Court is we're back to where we were as recently as Clarence Thomas. The executive calendar is dealt with a simple majority. I think that's better for the country, and they'll benefit from that too at some point. When you have a president and a Senate of the same party, obviously this is going to happen quicker. That's the way it's always been. Whether the rule allowed a filibuster or not. So ironically, we're back to where we were. The entire executive calendar will now be dealt with as it was a few years ago, before all of this back and forth, with a simple majority. Well, obviously, Justice Gorsuch was confirmed on a bipartisan basis once the executive calendar was returned finally to a simple majority. And then Justice Kavanaugh. Most of us were here for that. Despite the horrific and embarrassing display that some of our Senate colleagues aided and abetted, we made it through that. So the good news is this: in about 72 hours, I anticipate we'll have a third new Associate Justice of the Supreme Court. In about 72 hours. I do not blame some of my Democratic colleagues who were not present for all of this, who wish the Senate would behave differently. But just know this: this is not spin, this is fact. Just know this: every new escalation, every new step, every new shattered precedent, every one of them was initiated over there. No exceptions. Every one of them. And it all happened over the strenuous objection of Republicans who tried in each instance to stop Democrats from trading away long-term Senate norms for short-term political wins. 17 years ago, colleagues, 17 years ago, Democrats were boasting to newspapers about this brand new campaign to politicize judicial confirmations. They thought it was a great idea. Bragged about it. One of my colleagues called himself the king of the filibuster and proudly wanted to own it. Well, sooner or later, the shoe is always on the other foot. So I hope our colleague from New York is happy with what he's built. I hope he's happy with where his ingenuity has gotten the Senate. Colleague, we've had this argument over and over for months, if not years. This is not really what we are here to debate today. We're here to actually consider an outstanding nominee whose qualifications nobody doubts, Judge Amy Coney Barrett. So, colleagues, let's get on with it. Let's do our job. Let's rediscover the rational treatment of nominations that the Democratic leader embarked on a deliberate project starting 20 years ago to erase. We will give this nominee the vote she deserves no later than Monday. I yield the floor.